secondly. Gotta go over here. Unbelievable.
Don't play with how you treat me.
Alright.
Using my things and it acts crazy.
I'm not acting crazy, dear. I just asked you if you had it.
When I was answering, you started jumping on me.
Well, no,
again.
I accepted your answer. It's just I couldn't sit there.
I don't want that kind
Sweetheart,
of
just
response.
sweetheart, I don't know, but just because I ask you a question doesn't mean I have the rest of the day
No,
to
I
talk
know
about
what
it.
you're talking about.
I just asked if you
know
had a
how
recording
I feel
device.
what you're feeling.
Does your phone records, doesn't it? But you don't know how to do it, right?
I'll just leave my stuff alone.
Okay. They might be jamming it now too, though. They usually do. Wow, we had a decent judge before. So this woman up says she's going to date stamp to make it look like I just brought it in today, right? They're lying cheats and bastards. Okay? And that's what they do for a living. So, let's see. What they're going to do is try to block any due process. They're going to try to get it through. Okay. This is really slow.
I don't even know what I'm doing here.
Well, we have to wait for the phone call here. We're going to have to bring this over.
I thought we were going to go into a meeting with face-to-face.
I know, but they said that they refused to do that.
Right now?
Yeah, they refuse to do that now. They lied. Probably she has some kind of a dumb admin.
We came down here for nothing?
No, we didn't come down here for nothing.
Did it someplace
They
else?
make you. No. First of all, no. I don't have room and space in there to have a phone hearing. Okay? They got all the nice offices and then they make us be on the phone supposedly for our convenience. It's not convenient. What it does is take away our rights. It's not convenient at all. If I ask for convenience, can I do it on the phone? They just can go ahead and do it. But don't pretend they're deciding for me what's convenient for me when they don't let me confront the people who are stealing your cancer care.
They're not going to do anything.
Well, they're doing stuff right now. And by the way, they're not the only one that can do stuff. The people can do stuff now. What they do today can be on the internet in minutes. Okay? They're not protected that they can hide behind, big walls anymore. Oh, this is dirty. Dirty pool. Okay, now it appears that they're late. What's the phone that you got?
What?
What's the
Why do you
phone
want my
number you
phone?
got? They're not calling.
I don't know what their phone number is.
They were supposed to call. Okay, where's the paper in case they don't call? I don't know, they seem to think that this is like a game or something. I don't know why they do this. Okay, put it on speaker.
For information on how to file an appeal, press 1. To file an appeal for the food support program only, press 2. To leave a message for the appeals division, press 3. For our contact information, press 4. To speak to a representative or to get information on how to file an appeal online, press 0. To repeat this menu, press the star key. Morning, State Appeals Office. How may I help you?
Hello, yeah, we're here for this appeal, and then somebody said that we're gonna get a phone call, and it's 7 minutes late, so I'm wondering, what's going on. Nobody called us.
Okay, what's the docket number?
Okay, just a minute. Okay, 196240.
196240.
Yeah,
And your name?
my name's Steve Carlson. My wife Vicky is here too.
Okay, what's the number you guys want to be reached at?
Well, it's 651-815-8552.
So 651-815-8552.
Yeah, it's this number.
Okay. I will go bring this message to the judge. Anything else I can help you out with today?
Well, I'd like to know why we're not meeting face to face when I brought in a note, left it down here on the 16th. And I thought I could trust that. I didn't know I couldn't trust it.
It's up to the judge as to what type of hearing they'd like to hold.
No, it says according to the law that I have the right to do it. It's the hearing rules.
I can certainly transfer you over to her line and you can speak with her, but she did not provide a telephone number, so that's why you didn't receive a call. What I'm going to do is I'm going to go bring her the phone number so that she has it, but I can also transfer you over so you can let her know that you wanted an in-person hearing, not a telephone hearing.
I think we'll talk about that when she calls us.
Certainly. All right, I'm going to go bring her the message. Anything else I can help you out with?
No.
All right, thank you. Have a good day.
Yes.
Don't fight these people.
What are they talking about? We didn't provide a telephone number. We've been doing this before.
Don't fight the people. Make things
So
worse.
she said that they didn't have a telephone number. So they're going to let it go. They're going to make it be that and say, well, we don't have a telephone number. Let's just dismiss the whole
You
hearing.
make things worse. You fight them.
They're dirty.
You fight them, you make things worse.
Oh, we are fighting it.
I said if you fight them when you talk to them.
No, it's not fighting when I talk to them. All of us fighting when we talk to them.
That marrying a person that
Okay, now, Vicky,
hated
let me
people.
handle this. Remember how I said let me handle it?
You hate people. It's not
I
fine
don't
for
hate people,
you.
but I'm saying let me handle it.
You just leave me alone. I'm just sitting here.
Okay.
I will walk away.
I understand. It's a good thing I called him. Why would I provide a telephone number when I provided them a note? And how could they have confirmed with me that it would be in person, when in fact they claim they never had my telephone number? See what I mean? Obviously, we never confirmed it would be in person, and we brought the note in. Okay, of course we have to be cool. You know what I mean?
I don't even know how to be cool.
I am being cool, but if they're not going to let us have a hearing, it's pretty hard to be cool when there's no hearing.
I don't know about you, I just know how to handle, I know how to treat people myself, but I don't
Well, I know. You're good. So they say, so instead of bringing a number, I told them I want it in person, and I have the right to it. It's a legal right, it's in the law, it's in the point 451, it's the hearing rules. It's 256.451 of the 2016 Minnesota statutes. Okay? And they think that they can steal from me because that's what they go to law school to find out how to do. It's like, what are we going to do to this guy? You know? This is not an easy thing in the first place. You know what I mean? Because they never gave us any kind of notice of what they plan to do. They just say, okay, all your medical assistance is going to be removed. And they never gave any reason. They removed it from a program you don't even know. You know? So that's why the judge said that they had not provided adequate notice and that there needed to be another hearing. But then she still went ahead and tried to take action even though there wasn't a hearing with notice. So you saw that was about 6 minutes after they were supposed to have called me, if they wanted to call me, which they weren't supposed to call me. But they insisted, and they, without telling me, refused to allow a face-to-face meeting. Violates the state statute. So let's just go straight there. That's subdivision 10. Telephone or face-to-face hearing. It shall be conducted with all participants personally present, not represent, all participants personally present before the Human Services Judge. That's from the Minnesota State Law. Okay? And it says, we want them all present. I mean, that's what they said. We need to see the HSJ in person. We do not want a telephone hearing. We want an in-person hearing. Then that woman up there trying to pretend I just brought this photocopy today. They have the original. I give it to them. They say immediately they log it into the appeal office.
What's happening now? What's happening now? How long do we have to be here?
I have to be by the phone. honestly don't see how they claim they definitely had a phone hearing set up and talk with me when now they say that they never provided my number. So how could that be true? Possible. It can't be true. Okay? It's just pure fiat. Where the government says, there, I did it, what are you going to do about it? You know?
How long will I have to be here?
Hmm?
How long will I have to be here?
Until she's supposed to call us now. Maybe I better call again. Since it's approached, it's over 15 minutes now.
For information on how to file an appeal, press 1. State Appeals Office, this is Katie. How can I help you?
Yes, Katie, I thought I better call back because I still haven't heard anything on this phone hearing. I talked to you almost 10 minutes ago, so.
Okay, who's the judge on it?
Kralik.
Okay, I'm not sure why they haven't called you. I'm just going to transfer to her line. Just a moment.
Okay. Okay, they're on now. I'll just tell her what we want, okay? Now they want to answer the phone.
This is Nicole Kralik, Human Services Judge at the Appeals Office at the Minnesota Department of Human Services. I'm not able to take your call now, but you're welcome to leave me a message. If you have any general questions about appeals, please press 0 to contact our support staff. If you are calling about a specific question on a particular case, such as a request for a continuance, please leave me a message. Our fax number is 651-431-7523. If you want to avoid listening to this message in the future, please press pound when you hear the
I'm
greeting
gonna ask for a
and you will
continuance.
immediately access my voicemail. Thank you. Record your message at the tone. When you are finished, hang up or press pound for more options.
Yes, Judge Kralik. This is Stephen Carlson with Stephen and Victoria Carlson, docket number 196240. We've been in contact with the office there, and we're kind of awaiting the call. However, we do want a continuance. The other side never filed an appeals summary, and they're required by law to do that. And of course, you're supposed to check up and make sure that there is one for every fair hearing, and this is a fair hearing. I have talked to the commissioner's office, and they have said that this hearing is supposed to go forward by statute. And so it should go forward, but we need an appeals summary. We do not want a phone hearing. We want a face-to-face with all parties, all participants present. So that's the message. I hope that you can grant a continuance under these circumstances, and if you'd like to talk about it more, we could do that. Thank you.
To send this message, press pound or hang up. To play, your message has been sent.
Okay. So there it is. We asked them, but if they want us to go forward with it, we can't.
So then nobody's gonna call?
I assume what they're doing is they're playing with the other side. She's in an ex parte contact with the other side, and they're begging her to dismiss this because they got something about a court or something like that.
So how long will we have to wait here?
I would say we need to continue to wait until further notice. It's a good thing I called them, because it does say under there, before the hearing, provide the number where you can be reached. Well, I don't want to be reached. So I didn't provide the number, and then these people, they pretend that I never brought it down there. And just because I didn't have them date stamp the copy for me, I trusted them, which is stupid always, trusting the government. Here it is. Hello?
Hi, is this Stephen Carlson?
It is.
Hi, it's Nicole Krelik. I'm going to add you to content.
Did you get my message?
Just hold a second. Miss Phillips, are you there? Yes, and I have Mr. Stephen Carlson on the line. I'm recording this, and this is Human Services Judge Nicole Krelik. Today is August 24th, 2017. It's 10:30 a.m. This is docket number 196240. This is a pre-hearing conference to determine jurisdiction and determine what the issues are, and to see if we're going to proceed to an actual evidentiary hearing. Present are Mr. Stephen Carlson, who is the appellant, and then, or the appellant's representative. I believe he's representing Victoria Carlson.
Yeah, and Victoria's here too.
Okay, great. So Stephen and Victoria Carlson for the appellant, and for the agency, I have Ms. Ebony Phillips for Ramsey County on the line. So like I said, we're not doing a full hearing, and I'm pretty sure, Mr. Carlson, I had my paralegal call and explain that.
No, you don't even have my number.
Okay, I don't know. I left a message. I
No.
got a message and I sent an email.
Well, I didn't hear it. I'm sorry.
The situation, sir.
Mhm.
When I schedule a telephone hearing, we do a telephone hearing, right? If I schedule...
No, ma'am. There is a law which is subdivision 10 of 256.451. That's the hearing rules, and I have the right by law to request it, and then everybody has to be present. They can't do like they did last time, sit on the phone. That's the Minnesota law.
Okay. Well, sir, let me tell you this. For actual hearings, you do have the right to an in-person hearing.
Okay.
Or we could do it by video conference. That actually is...
Okay, we agree.
However,
Yep.
first we have to get to the point that we understand. Because what I'm hearing is this is why we're having this pre-hearing conference. Is
Okay.
to check in to figure out what the issues are. Because it's my understanding that there was already an issue about that Ms. Carlson is not eligible for medical assistance and BC, and therefore now there's a renewal due, and that apparently the issue is the agency is trying to figure out if Ms. Carlson be eligible for MA with a send down. However, the appellant is saying that we don't want to do the renewal.
Okay, how did you reach that understanding, Judge?
By looking at some information from your notice of action that you received.
Okay, so looking at the notice of action from the county.
Mr. Carlson, what is your issue? What are you trying to appeal?
Okay, well, first of all, I want to say that Brenda Kiepert Holthaus, you know her? She's an attorney in the commissioner's office. She's reached out to us and said that this hearing will take place by statute, and that the determination from the previous hearing on the first date, which was April 23rd, is not final because we filed and served a notice of appeal on Monday, August 21st. So we've made a submit. Yes?
I'm asking you a straightforward question.
And I'm giving you my answer.
Well,
Okay.
that doesn't make any sense because you're talking about a previous appeal that's been already. I looked in the record and it looks like.
You know,
When you requested redetermination and that request was denied.
I'm sorry. I am.
Can't file a new
Okay.
appeal.
Okay, I'm trying to answer you, and I'm simply notifying you that Brenda from the commissioner's office, who is an attorney, reached out to us with an encrypted message that I have a copy of that said that this hearing will take place by statute. That's what she said. And now we made a submission to this hearing. Now let's see. Let's go straight to this. I want to touch on the fact that we're talking today because Judge Longfellow, who presided over the first hearing, April 23rd, found that the county had failed to provide us with adequate notice before they deprived Vicky of medical assistance. So in fact, there has not been a previous hearing because there's been no adequate notice. Now that's a due process requirement that's based on the 14th Amendment, the U.S. Constitution, which governs both state actions of Minnesota and its subdivisions, including Ramsey County, as well as actions taken under color of law. And this action challenge is related to the actions of the state and of the county taken under color of law, and officials acting under color of law. And those actions dated October 5th, 2016, this is the previous thing you're talking about, were simply to cut off all Medicaid to Vicky. And according to their records, they have paid nothing past November 30th of last year. Now, there might be a few payments they have made in late June of this year after Judge Longfellow's ruling, but as after it was adopted by the Commissioner's office. But as far as we're aware, that's all. And after the Commissioner accepted Judge Longfellow's recommendation on June 8th, the county issued another notice of action, and we filed an appeal of that. We did request that benefits for Vicky remain in place during this appeal as well. So Judge Longfellow has instructed the county to try again, to try to meet the state law's requirement of giving us adequate notice so we would know what they're doing. And actually, it should be what they're proposing to do, but they just went ahead and did it with no notice. And we are supposed to have a chance to talk about it before they carry out that proposed action. And Judge Longfellow, in her recommendations adopted by the Commissioner, now she's talking about transferring Vicky from MABC, medical assistance for breast cervical cancer, to an elderly program, which is not a cancer treatment program and requires a spend down, which Judge Longfellow said effectively bars Vicky from receiving any Medicaid dollars for her medical care during the course of her cancer treatment. So let's be very clear on what we're saying here. We're saying the county, through their notice of action, which we challenge here, is now proposing a change, and that change is a decision affecting changes in methods and procedures of payment. And again, they don't propose, they just act. They have already again deprived Vicky of any Medicaid dollars. But I think we can all agree here that this proposal by the county, if adopted, would definitely be a decision with the action already taken affecting changes in the methods and procedures of payment of Vicky's Medicaid benefits. And I'm going to show you that mandates of changes in methods and procedures of payment must be consistent with the principles of economy, efficiency, quality of care for Vicky, and equal access to Vicky. And a big issue here is whether the changes proposed by the county, and again, I need to say they already carried out that plan last October. Apparently they and other Minnesota counties do this for hundreds of women in the state. But that is a decision affecting payment of services, and it is not at all consistent with the principles of economy, efficiency, quality of care, and equal access, all for Vicky and her cancer care, which she's entitled to. So obviously it's not. So I'm speaking specifically of this transfer, which Judge Longfellow instructed the county to give us adequate notice of, so we could have an opportunity to discuss and to contest it here. And to be clear, they're trying to do again what they already did in October because of the fact that Judge Longfellow tried to undo some of what they did in her recommendations. She reversed their actions adopted by the Commissioner. That was because basically what the county did in October didn't make any sense. They failed to give adequate notice to us what they were going to do so we could have the opportunity to be heard in a face-to-face hearing and contest it. And while I'm on the U.S. Constitution, we protest not being able to discuss our rights and Vicky's rights under the Medicaid program that are secured for us by the U.S. Constitution. I've addressed the 14th Amendment, and these same rights apply for the 5th Amendment, protecting us against violations by CMS and Congress, if that had occurred. And according to my research, the federal government gave these rights to Vicky and is not trying to take them away and replace them with this spend down, which bars her from any Medicaid dollars. And so the federal law and policy supports Vicky's right to receive Medicaid, paying the balance of what Medicare will not cover to the end of her treatment. So the due process clause the clause against arbitrary and capricious decisions and actions by the county, which this is another example of, the protection of privileges and immunities of all U.S. citizens, which Vicky is, and notably the right to age and treatment. That is a civil liberty to age and treatment, and the county violates it by penalizing her for attaining age 65 while in cancer treatment. But the government is constrained from penalizing her as a recipient of this treatment, and that's a violation of the Constitution. And then there is the Equal Protection Clause that's violated here. As I've said, they've created a suspect classification of age within the people in the program, and they damage and they take malicious action against them, and they have no compelling state interest for that. And it also doesn't even have a rational basis, which is the lowest standard of the equal protection, because you're giving money to people, then taking the treatment away, which means that the money is being wasted. And the reason I try to present these constitutional issues, even though the state legislature has passed a law saying her constitutional rights may not be protected in this administrative appeals hearing, is first to raise a protest against that state law for violating the U.S. Constitution. And as Judge Longfellow stated, even though the Human Services judge may not entertain them, she may still comment on such issues as due process through adequate notice, as Judge Longfellow did. But
Mr. Carlson, I want you to back up, because you're kind of getting into the argument you would make at a hearing, and I'm really just trying to figure out the issue. So what I hear you saying is that you disagree with the determination that that Vicky Carlson is not eligible for MA under the breast cancer program.
what I'm saying is,
As you continue to argue your points about that, you want continued benefits for her on that program.
what I am saying is that we have not yet had the fair hearing, which under state law, and by the way, this is also required under federal law, because she's asserting a claim. I believe this is of 1396A, I believe it's A3.
You're arguing, I need to understand, so I'm sorry for interrupting you, but you're arguing that the hearing that you had in front of Judge Longfellow wasn't correct under the law, and therefore you want that looked at again.
Well, she herself.
You want to have a hearing on the same issue with a different judge.
It's not. No, it's not an issue of the same issue with a different judge. They are proposing a whole package which we never knew what it was for that hearing, and the judge has admitted, and she's concluded, and the commissioner knows, that there was not adequate notice of that hearing. Adequate notice means what they are proposing.
What are you talking about? What hearings did you not have adequate notice of?
First of all, this one, because they still didn't say what they propose and what are the grounds. And
You know we had a hearing now. You got a hearing notice in the mail. That's why you called me.
yeah, well, I'm not in a hearing yet. But I'm saying, notably this one, but that one, we also were not given the proposed action. The hearing.
What is it that you did not have at your last hearing that's bothering you specifically?
Adequate notice where it said.
Notice of what though? Notice of the hearing? You didn't get your summary? Like what did you not have?
The adequate notice was, so are you thinking of overruling what Judge Longfellow said and saying that there was adequate notice and there was due process?
I'm trying to understand what you're telling me.
Okay.
I don't understand what you're saying. I'm not making any decisions here. I'm just trying to clarify the issue. That's why we're having this pre-hearing conference. You know what? I'm going to ask you to step back for a moment, and I want to hear from the agency, and then I'll give you an opportunity to respond, okay? So, Ms. Phillips, can you fill me in here? Maybe you can illuminate me a little about what the issue is going on here. Well, from everything that I'm seeing, and I'm getting lots and lots of documents from Mr. and Mrs. Carlson. Yeah. I have a document that I'm just getting bombarded with documents. Every single document is very detailed information, but when I with lots of words, and when I go through the crux of the matter, always ends up as we want MABC right now. time that happens, I try and write a summary to the call so to kind of break it down in other words as well, so they have both the court, the rulings from DHS, and then also a county breakdown of that in case they need further clarification. And it just keeps being met with more demands for MAPC to be open and more refusal to turn in a renewal for medical assistance eligibility determination. So at this point in time, the case is closed. We have no renewal paperwork to assess eligibility for any program, and MAPC they're just not eligible for that program, unfortunately. Those are the policies, and we have talked to them about how if they want to bring this to, other agencies to dispute, I don't know, that the court system and all of that, that's fine, but that doesn't have any kind of ruling on opening MAPC, because the reopening of a closed program pending appeal pertains to the DHS decision, and that has already occurred. We reopened the MAPC program pending appeal. The decision came back. Case was closed. Adequate notice is 10 days prior to the action. That was sent out 10 days prior to the action. Also, at the time of the appeal being opened, there was a explanation saying this reopening of MAPC is solely because of the appeal pending regulation we have in our policy before a hearing. And so Mr. and Mrs. Carlson have been notified every step of the way in this. As soon as I took over this appeal, I can only talk about when I took over this appeal because this has been going on for quite some time. And when I took over this appeal, I always made sure that every step of the way there was an explanation of what was going on. And so that's always happened since I've been working with this appeal. And at this point in time, I don't know what else to explain because there is no reopening of MAPC anymore. This issue, as far as DHS is concerned, has been addressed. As far as Ramsey County is concerned, based on the DHS decision, has already been addressed. Okay, thank you so much. Mr. Carlson, you may respond.
Thank you. Well, first of all, I would want to point out that she said that she doesn't know anything about the federal law, and she said before she doesn't know anything about the state law. And yet, her job is to administer those laws. Now, this is a very special program. I don't know if either of you are aware of it, but this is a federal program. It's not. It's an optional program that's been adopted.
I'm familiar with MAPC. I'd like to hear you respond to the issue and tell me if you disagree.
Yeah, well, it's a very unique program. It's a life-saving program that's been cut off during treatment. And to me, that is a very relevant fact. Now, as far as what she said, she admits she does not know the federal law or the state law. What we need is, if an action's going to be taken, they have to tell us what it is, and they have to be very clear telling us the federal applicable law and the state law so that we can discuss that. That was never done, and it has never been noticed. Are you familiar with the first October 5th notice of appeal that didn't give us adequate notice? It was saying that she had been, since July of 2016, requiring a spend down, and that she failed to provide bills over and above the spend down that she had. And the judge concluded she didn't have any spend down, and she wasn't on that program, and so that's why it was inadequate notice. Now, she said she just took it over. Well, that doesn't hide the fact of what the first hearing was about. And in the middle of that hearing, the judge and her still couldn't figure out what they had done. She said, I don't know why we did that. I don't know why we haven't paid the benefits during this appeals process. I'll have to look into that. And that was called a hearing. Now, the fact that Judge Longfellow did go ahead and issue some recommendations, one of those findings was that it was not adequate notice. Now, we have a constitutional right. This is from the United States Constitution. This isn't just give us MA. Can I say this because she said that? That is very, I want to say this very politely, but that is very mean and wrong to say that all we're trying to do is get something that Vicky isn't entitled to. Now, we can get into the merits of it. What I would suggest is this. If she feels that strongly that this is the appeal summary from the point of view of the agency, I would like her to put that in the form of an agency appeal summary and mail it to us so we can have this very discussion. Now, you're saying that, well, some element you think has already been decided. Well, first of all, it wasn't before the judge in that hearing. What was there was the October 5th hearing. The October 5th notice that all Medicaid was to be cut off because she hadn't turned in spend-down documents, which she wasn't supposed to. And it was totally irrational what they did. So they can't just, out of a big chaotic mess, isolate one thing that they feel has already been decided, even though everybody knows that it was not put forward in a way where people can know what the issues are and present their case, which is in the rules. So this hearing has to follow those rules. Now, I would argue still that they should put in their appeal summary, and they should have put in their notice of action what the proposed action was and what their grounds are. But instead what they said was, well, just we would refer you to this recommendations from the judge in the hearing. Well, that is not notice. If they don't know well enough why they feel they can do what they are proposing to do, whatever it is, which is basically to bar her from all Medicaid. That has never been decided, that hasn't been argued that she's going to be barred from all Medicaid. Now then they say, well, if you turn in something, we're talking about Medicaid on the basis of being a breast cancer patient, still in treatment. There's no way that that is allowed, okay? And do I disagree with it? Absolutely I disagree with it. But we want due process where we look at the totality of their action, taking not only that program away, but barring any Medicaid dollars that would normally be. There are the details are set out, and they should be allowed to proceed, and they're not stopped by the fact that what we did, and I mentioned Brenda at the top. She is the lawyer. I don't know why she reached out to me, but I had been talking to Andrew Johnson, and because Emily Piper had reached out to me on Twitter. And she referred me to Andrew, and finally Andrew referred me to Brenda, and they looked into this, and they said this hearing will go on according to statute, and the case still needed to be filed because of the wrongful nature of the Longfellow and Commissioner's action, which is basically to say, okay, we haven't had notice, okay, but we're going to still act. So you have to have notice, and these are our rights. You have to give us our rights, and we'll be talking about them a long time.
Because we have run out of time.
Okay.
I understand what you're saying.
Mm-hmm.
I do understand what you're saying. So this is what's going to happen. I'm going to end this conference. I'm going to make a decision as to whether or not there's jurisdiction. And you will, if there is, we will set a new hearing, an in-person hearing. And if not, you'll get an order
All right.
about that.
Let me ask you this. Jurisdiction. What jurisdictional statute is the county arguing on, and what jurisdictional statute are you looking at so that we'll be aware of it and we can study that and have input into that decision?
It's a double docket.
I'm sorry, what? I know, but what
It's a double docket. Have these issues already been litigated?
what is the jurisdiction? That's not jurisdiction. That's res judicata. I'm asking you, what is the jurisdictional authority which you're pointing to which would limit the jurisdiction? Can you tell me or not?
There's a statute involved.
And what is the statute involved so that I can...
I'm going to end the hearing, sir.
All right.
I have another hearing scheduled. Thank you very much. Thank you, Ms. Phillips, as well. Thank you.
You're too loud. Not telling everybody in this
I need you to be
way.
quiet a minute there. I got to get this recording. I have to concentrate on what's going on here, okay? Okay, now.